Good afternoon, everyone. I'm Jennifer Clark, the Manager of Programs and Operations with the New York State Coalition Against Domestic Violence. And welcome to today's webinar on the Virtual Legislative Day of Action Preparation webinar. Before we get started, I'm going to go over just a few housekeeping items for today's session. You'll notice that we have this set up in webinar mode, so all participant video and mics will be muted. We do ask that you post any questions you have in the chat box, and a staff member will respond, or we will read it as part of our question and answer period during today's webinar. Closed captioning is enabled, and you can find the ability to turn captions on or off in your toolbar. There is a link in the chat box to view the presentation slides for today's session, and a copy of that, as well as a link to the recording, will be sent to you in a follow-up email. And with that, I will hand things over to Director of Public Policy and Advocacy, Joan Gerhardt.
Thank you, Jennifer. Thank you for your assistance with today's webinar. And I want to welcome everyone to the 2022 prep webinar for our Virtual Legislative Day of Action, which is coming up on April 26th. Before we begin, I'd really like to start by just telling you what the objectives of today's webinar is. It's really to run through what we hope to accomplish on our Day of Action in a couple of weeks. The messaging that we hope to convey, what we want legislators to know and to learn about domestic violence survivors, as well as service provision of domestic violence services, and also how NYSCADV can support you on your activities during the day. We will review some of the information in our social media toolkit, some of the materials that we are just in the process of finalizing for you to use in your own preparation for meetings, as well as leave behind materials for legislators, and some information on how best to schedule meetings, what to do in preparation for those meetings, and certainly to answer any questions or concerns that you have about the day. So I think it's a good, sometimes it's a little difficult to get these meetings started with legislators. So I wanted to give you a few tips on some ideas before we get into the nitty-gritty of what we're hoping to convey on, some ways to just start talking to legislators. And I think, we have a really good avenue to start these meetings with passage of the New York State state budget, which just was finalized over the weekend. And there's some really good news in that budget for domestic violence survivors and service providers. And it really gives you a way to start these meetings on a positive note. So in a very high level summary, some of the things that were included in the final budget was a transfer of $14.4 million from general revenues over to the Office of Victim Services to address that VOCA shortfall. So I think many of you are probably aware that the federal VOCA grant that has been coming in from the federal government has been decreasing in the past several years, and OVS as a result threatened all of their subgrantees with significant cuts. So this $14.4 million is intended to ensure that no program is cut in terms of their funding when the new grants are issued to begin later this fall in October 2022. So that's very good news, and we were advocating really quite strongly to ensure that no programs had their funding cut. Another thing that you might want to thank legislators for is the continued focus on funding for non-residential domestic violence services. We got $3.2 million in this year's budget. This is the same level of last year. And even though we didn't get an increase, we do want to thank them for maintaining that level of support because of the importance of non-residential services for survivors. We also did get another $5 million for the OCFS pilot project to evaluate a new methodology for funding domestic violence programs, which is important. And the legislature and governor saw fit to remove the mandate for 40 hours of training for domestic violence advocates, as well as creation of a training institute at OPDV. Now, while some of that proposal might have merit, we didn't feel that OPDV should be responsible for training advocates in New York State, and we weren't quite sure that there was universal support for a 40-hour training mandate in statute. So we're very pleased that this training institute and this training mandate didn't make it into the final budget. Another way to start your meeting is to talk about how New York State consistently has the highest demand for domestic violence services in the country. And the numbers you see here are from the latest NNEDV DV Counts survey. We had well over 6,600 survivors obtaining services, both residential and non-residential, on that one day in 2021. And thank you to everyone who participated in that survey. If you can believe it, we're already prepping for this year's. But I think most important is that we had more than 750 individuals unable to get the services or support that they were requesting. And 72% of those requests were for housing or emergency shelter. So that's really a concern. And I think it's important to convey to legislators the context, the need that survivors have in New York State. You know, this is really a crisis. There are many New Yorkers experiencing domestic violence or having violence in their families. So this is not an issue that they can put aside. This affects a great number of New Yorkers, and they should really be committed to ensuring the services and supports for these vulnerable New Yorkers. And we know, what we want to tell legislators is we understand the crucial role that they play in our work, and we share many of the same goals. We want to safeguard these supportive services for all survivors. We want to ensure that programs have the funding and flexibility to support survivors the way that they need. And we know that legislators have the authority to make critical decisions based on the budget and also with legislative initiatives. And when we look at legislative initiatives, it's very important that they be equitable, that they be informed, and that they aim to reduce harm, again, for all survivors. So with that, that probably gives you some thoughts about how to start your meetings. But now I'd like to talk about the specific legislative bills that we have identified for discussion on our day of action. And we've identified 6 bills. I want to say at the outset, we don't expect anyone to cover all 6 bills in their meetings. Most of the legislative meetings will probably run about 20 to 30 minutes, and that doesn't give you nearly the amount of time needed to go through 6 bills. The intention here is that you, in advance of the meetings, review the information on these bills and really decide which 2 or 3 bills mean the most to you or to survivors in your community. Which have you had direct experience with? Maybe survivors have had direct experience with, and focus on those, because we'll be providing leave behind materials for you, for the legislators, that describe all of these 6 bills. So it's really not necessary for you to cover it all in your meetings. Now, when I go through these series of bills, we're going to talk about each one. I'll give you the bill numbers so you can look them up yourselves. I'll also let you know as of today which committees these bills are in. But we will update this information just before April 26th, because it is possible some of these bills will move through some committees in the next couple of weeks before our day of action. So what are the bills? We have a bill to ensure fair access to victim compensation, a bill to enable domestic violence survivors to self-attest to their status as a victim in order to break phone, utility, and TV contracts. We have our comprehensive sex ed bill, which many of you are likely familiar with. We have a bill that would ensure residents in temporary housing and shelters, including domestic violence shelters, get free internet at the full cost of the state. So that's not requiring service providers to pay for that. It would require the state to be responsible for paying for that cost. We have a bill to ensure access among family court litigants and counsel to forensic child custody evaluation reports. And finally, we have the Adult Survivors Act. So those are our 6 bills. And now I'd like to take them apart one by one and give you some reasoning for why these are on our list of priorities. So first, the Fair Access to Victim Compensation Bill, a bill that was introduced in the Senate by Senator Myrie and now has a companion bill in the Assembly. So we know that a very small percentage of victims actually receive victim compensation from OVS. There are several eligibility requirements that make it difficult for victims to obtain the compensation, particularly mandated reporting of harmful incidents to law enforcement. That's one requirement, as well as a very limited time frame to file claims. So current law prioritizes punishing the offenders over helping survivors, which really re-traumatizes victims by forcing their involvement with the criminal justice system. And we know many victims are not interested in engaging with the criminal justice system. So this bill would specify that a victim is eligible for compensation regardless of whether a suspect was arrested, charged, apprehended, or prosecuted, and whether the victim interacted with the law enforcement agency that's investigating the crime. So they don't need to report the crime, and they don't need to collaborate or cooperate with the law enforcement agency who is investigating the crime. That's a very significant change. Second, current law requires a police report to be submitted with the compensation claim. This bill would expand the types of documentation that a victim can provide to support the claim to include self-attestation. So a survivor can just submit a written form saying that they were a victim of a crime, a statement by a victim service provider, a medical or mental health provider, statement by a witness in order of protection, or a video, audio, or photo recording of the crime. So greatly expanding the documentation that can be submitted with the comp claim. And finally, the bill increases the time frame that a victim can file a claim from 1 year to 7. So that's also a pretty significant change. So this bill is currently, this is a new bill, so there's really no history on it. It's currently in the Senate Crime Victims, Crime and Correction Committee, and in the Assembly, it's in the Government Operations Committee. So, and if anyone has questions on these bills as I'm going through, please put them in the chat. I'll try to address them as we're going through, unless Brittany resolves it in the chat itself, or we can answer questions at the end as well. So now I'd like to move on to our second bill, which relates to reducing barriers for domestic violence survivors to break phone and TV contracts. So we know that these family or bundled contracts and plans can be dangerous for domestic violence victims. The person who controls the account can access a survivor's call history, can access the location of their phone or other devices, and can use the technology to harass and intimidate. These contracts can also be used as an economic abuse tactic by racking up arrears to impact a survivor's credit. In 2019, a law was approved to permit victims of domestic violence to cancel these bundled contracts. But to do so, they needed a third-party attestation, something like a medical or mental health provider attestation, a statement by a court employee, a domestic violence advocate, a social worker, or a rape crisis counselor, or they needed a police report a DIR, or an order of protection. Now, last year in 2021, this was expanded to include utility contracts, which was great, but it still requires this third-party attestation. So what this bill does, A6207B, is that it would make it easier for survivors to obtain this accommodation by allowing them to self-attest in writing to their status as a victim. So no longer would they need a police report, an order of protection, or any third-party attestation. And this is the same change that was made last year, enabling domestic violence survivors to self-attest to their status to ensure their voter registration materials remain confidential. So that's important because there is precedent to self-attestation. This bill also does a lot of other important things. It prohibits companies from not providing the accommodation unless billing responsibility is maintained. If the primary account holder approves the change, which obviously we wouldn't want, or if there are arrears on the account. So it would not require those arrears to be paid before the company provides the accommodation. It also prohibits companies from refusing to provide the accommodation if a survivor wants to change their phone number, which we have heard has happened in the past. Companies are restricted from requesting confidential information from victims who are seeking this accommodation. And it also requires them to provide the accommodation in 7 days after receiving the request. Finally, it requires them to destroy the information that they receive from a victim within 30 days of receiving it. And they must do it in a manner that preserves the confidentiality of the information. And there's one last important piece on this bill. They actually threw in the ability for domestic violence survivors to get a modified name or an unpublished number in phone listings, in phone directories, again with self-attestation. So this is a really important bill. We at NYSCADV have really looked at all of the accommodations for domestic violence survivors in statute, and we'd like to move all of these accommodations to a self-attestation approach rather than requiring a police report or DIR. So this would be really important to achieve that goal. And this bill passed the Senate last year, and it's already on the calendar for passage this year, which is a very good sign. But it is in the Assembly Codes Committee, so that's where we really want to focus. If you're meeting with any legislators who sit in the Assembly Codes Committee, this might be a bill for you to focus on in those meetings. So moving on to the comprehensive sex ed bill, or as I like to refer to it, the healthy relationships bill. This bill has been on our priority list for many years. We know that there's so much more about this curriculum than the birds and the bees. Many people like to simplify it to that, but this is a critical tool for building a culture of consent, preventing sexual assault and violence, promoting inclusive school communities, and improving educational outcomes. And it's an important step to prevent sexual harassment in our classrooms and in our communities. And there's a large coalition that supports this bill, and NYSCADV is proud to be a part of that. So just a bit on the statistics. Nationally, more than 2/3 of teenagers who are or have been in a relationship report experiencing some form of sexual, physical, or emotional abuse. And in New York, about 10% of teens report experiencing physical dating violence. Studies show that violence in adolescent relationships sets the stage for violence in future relationships, including intimate partner violence and sexual violence perpetration. So comprehensive sex ed teaches students about bodily autonomy, personal boundaries, privacy, and how to tell the difference between a healthy and unhealthy relationship. It instills in students of all ages empathy and respect for each other, and let students know how and where to get help if they're being abused or harassed. And it promotes respect and inclusion by helping young people understand sexual orientation and gender identity through lesson plans and activities inclusive of and relevant to LGBTQ youth. So what does the bill actually do? It requires the State Ed Department, or SED, with the Department of Health and a broad range of experts to create model curricula to support the implementation of a sex education program in grades K through 12. Now, districts and schools maintain the flexibility to teach the curriculum that is appropriate for their particular student population, as long as it meets the need, as long as it meets the standards that are included in the template curriculum. Now, legislators may be interested in learning that this bill does provide parents and caregivers the ability to opt their child out of this curriculum. This was an important concession that garnered a lot more support for the bill in the legislature, and we are hoping that there is momentum for this bill to pass the legislature this year. So this bill sits in the Education Committee of both the Assembly and Senate. So our fourth bill is something very different, which relates to the provision, the availability of internet for residents who are in shelters or temporary housing around New York State. So according to a May 2020 report issued by the City Bar Justice Center, only about 6% of homeless residents surveyed had internet access through their shelter. 6%. So although there's been increasing attention paid to the need for high quality, reliable internet access, and steps are being taken across the state to close the digital divide, New Yorkers experiencing homelessness and residing in temporary housing and shelters are unable to do many things that you need the internet to do, like searching and applying for permanent housing, searching for jobs, reliably participating in remote schooling, applying for government benefits, even obtaining telehealth appointments. Now, certainly the pandemic has highlighted the fact that reliable wireless internet is a lifeline and should be considered a public utility, a basic utility. So there's a broad group of legal and not-for-profit organizations, community groups, and activists who are urging the state to ensure individuals in temporary housing and shelters, including domestic violence shelters, are provided internet access free of charge. There was an effort late last year to get this included in the governor's executive budget, but that unfortunately was unsuccessful. So we're now advocating for passage of this bill, which would require local social service districts, so the DSSs, to provide and pay for internet services. So this would not be at the behest of service providers to make this available. This would be the local DSS paying for the full cost of the internet access and then having the ability to get reimbursed for the full cost by New York State. So NYSCADV is joining, like I said, a wide coalition that includes the New York City Bar Association, the New York Legal Assistance Group, the Coalition for the Homeless, the Citizens Committee for Children in New York, and many others in support of this bill. And the bill is in the Social Services Committees of both the Assembly and Senate. Before I move on to our next two bills, I just want to take a minute and make sure there's nothing in the chat, Brittany, that I need to respond to.
There's nothing in the chat right now.
Okay, so just
one more last minute. Would that mean DSS would be in charge of what internet company is used for shelters?
That is not explicitly laid out in the bill, so I think that that would be something that would need to be resolved once the bill passed. But I know that, in some areas there are multiple providers, in others there are fewer or more limited providers. So I'm not exactly certain how that decision-making would occur. More to come on that, I guess. Thank you for the question. So moving on to another bill that we've had on our priority list for some time, which relates to access to forensic child custody evaluation reports. Now, last year, NYSCADV participated in the Blue Ribbon Commission on Forensic Evaluations, which highlighted the troubling and challenging outcomes of court-ordered forensic child custody evaluations. According to the Commission's final report, judges order forensic evaluations too frequently and often place undue reliance upon them. Evaluators often rely on principles and methodologies of dubious validity, and in some custody cases, because of lack of evidence or the inability of parties to pay for expensive challenges of an evaluation, defective reports can escape meaningful scrutiny and are often accepted by the court, with potentially disastrous consequences for parents and children. As it currently exists, the process is fraught with bias, inequity, and a statewide lack of standards, and allows for discrimination and violations of due process. Which is why litigants' review of this report is so crucial to their proceedings. Yet there is inconsistency in how and to whom forensic evaluation reports are provided. Many parents and survivors report their inability to access or carefully review these reports, which impairs their ability to challenge the conclusions in court or even to make counsel aware of flaws and inadequacies in the report. Commission members agreed that the inability to access these reports and the underlying data, which is the forensic evaluator supporting file, created fundamental due process, fairness, and equal justice issues, which requires immediate attention. Assemblymember Helene Weinstein, one of our allies in much of our work, sponsored a bill years ago, years before the Blue Ribbon Commission was established, to permit litigants, their attorneys, the attorney for the child, and anyone retained by counsel to assist with the litigation to receive a copy not only of the forensic evaluation report, but also the evaluator's supporting file. Now, the court can place conditions on the distribution of the reports, and the court is required to notice the parties that willful failure to comply with any of these conditions placed on the distribution of the report would be contempt of court, punishable by fines, imprisonment, or both. And importantly, the bill would permit either party to object to the report and/or the evaluator's file from being admitted into evidence, and would require all the information to be subject to cross-examination. Some have raised concerns that abusers who have access to the information in these reports can publicize the information, which could cause harm to the other parent or to the child. And these fears should be taken seriously, but they shouldn't be used as a basis to treat these reports any differently than every other piece of evidence that is heard during these child custody proceedings. Plus, several states have permitted access to forensic evaluation reports to litigants and counsel for many years. NYSCADV has done research and outreach to some of these states, and as far as we know, none of these states are looking to change the laws that they currently have on the books. So if they can do it safely in their states, we can do it safely here in New York. So in terms of the status of this bill has passed the Assembly intermittently. It has not passed in the last couple of years. So it's now in the Assembly Judiciary Committee. It's never passed in the Senate, and it's in the Children and Families Committee there. And the reason why I'm telling you which committees these bills are in is because it's a good thing before you meet with your legislators to see which committees they're sitting on. And if any of these bills are in their committees, you can ask them to support the bill there. So now our final bill, which is really an honorable mention, which I'll get to in a moment, is the Adult Survivors Act. Now, we know that the link between sexual assault and domestic violence is really clear. A majority of women who are physically assaulted by an intimate partner have been sexually assaulted by that same partner. And when sexual assault occurs, all survivors deserve the opportunity to seek justice. But for many, by the time they make this pivotal decision in their healing journey, it's too late for them to seek justice through the courts due to insufficient statutes of limitations. And that's why NYSCADV has been supporting the Adult Survivors Act. This follows passage of the Child Victims Act, which was approved in 2019. That bill extended the time to file new civil cases for sexual offenses against a child until that victim is 55 years old. The Child Victims Act also created a look-back window for child victims of sexual assault to file old, time-barred cases in court. That window was initially 1 year, but it was extended to 2 due to the pandemic. And that look-back window closed in August 2021. But sexual abuse is not limited to children. Adults are assaulted, and these adults experience the same difficulties and challenges from coming forward. Currently, many of these survivors are denied the right to go to court and hold their offenders accountable because the time to file a claim expired before they had the resources or capacity to file a claim. New York did take an important step forward by extending the criminal and civil statute of limitations for most sexual assaults to 20 years. But this law only applies to assaults that occur in 2019 or after. That's why we need the Adult Survivors Act. The bill would create a new look-back window so adult survivors who experienced assaults before 2019 could go to court and seek justice, even if the assault happened many years prior. Now, on the same day as NYSCADV's Day of Action, on April 26th, members of the Adult Survivors Act Coalition, which NYSCADV is a part of, will be in Albany urging passage of this bill. Their focus will be on educating lawmakers about the reasons survivors have for not reporting sexual offenses, and that no survivor should be punished for taking the time they need to process their pain. We wholeheartedly support this effort and included the Adult Survivors Act in our list of priorities to send an even stronger message to legislators that we're all in support of the Adult Survivors Act. So this bill actually has passed the Senate. It passed last year, and it's now on the Senate calendar for this year, which bodes well for its passage. In the Assembly, it's in the Judiciary Committee. So that wraps up the 6 bills that we hope to cover on our legislative day of action. Before I move on, I just want to make sure there's nothing in the chat that I need to address, and I'm going to take a sip of water as well.
Hi, Joan, just a couple of things. Are there notes, or will there be before lobby day that remind us or update where the bills are in committee?
Yes, so we will, I'm not quite sure the mechanism we'll do this. We will either post information on the website where all of these materials, our bill memos for these bills, our materials leave behinds for legislators will be available on this website, and we'll post that website link on our DV Directors listserv. So we will either post the information there or we will just post the information right to the DV Directors listserv. Was there anything else, Brittany? Just that?
That's all I'm seeing right now.
Okay, thank you. So like I said earlier, during your legislative meetings, don't try to cover all of that information. It's a heck of a lot. So, really pinpoint 2 or 3 bills that you feel most strongly about and focus your conversation on that. The leave behind materials will include information on all of those 6 priorities. Before your meetings, certainly review the messaging and talking points that we're going to provide to you. Like I said, they'll be posted on our website, which is how we've been dealing with that in the past. So you're probably familiar with that. And it's also a good idea to identify survivor stories or circumstances for your program, or some local statistics that bolster the information you intend to provide. Now, before I pass this over to Brittany, our public policy coordinator, to talk a little bit more about logistics and materials, there were a couple of items I just wanted to present here to you that might be on legislators' minds. So these are issues that you don't necessarily need to provide information on proactively, but we want to give you some information that legislators might ask you about these items. And these will be included in our messaging, and particularly in a Q&A that we'll provide to you in advance. So, the pandemic still remains a tremendous issue. And, you might want to talk about this in your introduction with respect to the impacts the pandemic has had, not only on survivors and their families, but also on domestic violence agencies, which we know has been significant. So in terms of survivors, there's been a higher demand of services across the board, across the state. And the cases tend to be more complicated and involve more lethality. And we know that from a survey that NYSCADV has done a couple of times throughout the pandemic. So on average, we know that hotline staff across the state are receiving about 66 contacts an hour. So when you think about that, that's really troubling. And I'm sure you're all feeling that day to day. Now, we also know that there's been an impact to occupancy rates in shelters. And in some communities, it's been pretty significant where occupancy rates have declined. And because we have this unusual per diem reimbursement mechanism for funding in New York State, when occupancy rates in shelter dips, so too does the revenue that those residential programs receive as reimbursement from New York State. So this has meant, fewer bed nights, less revenue, but more demand, which has been extremely challenging for domestic violence programs to contend with during the last 2 years. Now, on top of that, we know that there's been changing rules and regulations that programs have had to deal with, from isolation and quarantine changes, vaccination requirements, mask wearing requirements. So it's been, an effort for everyone to stay up to speed on these changing state requirements, as well as local Department of Health requirements. So very challenging indeed. And we also know the impacts to our staff. With the Great Resignation that has been experienced across the state, particularly not-for-profits are having a very difficult time retaining or recruiting staff. And that's because most of these jobs are very traumatizing, challenging jobs, and yet advocates are only paid barely more than minimum wage. So why would anyone take on an advocacy role when they can have an easier job at a restaurant or at a Starbucks and make more money? And that's the difficulty. Which leads me to the second issue that you might get questioned about when you raise the issue of recruitment and retention, which is about the COLA, the cost of living adjustment that was just in the final budget, which is great news. For the first time in years, New York State has included a cost of living adjustment for healthcare workers in the final budget. And this is really important. Unfortunately, and this might be something you want to educate legislators on if they ask you about this, domestic violence advocates were not included in this COLA. So even though the funding stream for this COLA is nearly $7.5 billion, it was not enough to include domestic violence advocates in this COLA, which is very disappointing. So we're going to be working very hard to see if we can get a COLA for domestic violence advocates in next year's budget. But unfortunately, that didn't happen this year. So I mentioned a moment ago the per diem funding model, and we've been talking to legislators for many years now about the challenges of this reimbursement model based on bed nights. So it is possible a legislator asks you about the status of the per diem funding model. And really our messaging on this hasn't changed. The delivery system in New York State was established in 1987 as part of the Domestic Violence Prevention Act. It hasn't been updated since then. So what might have made sense back in the late 80s, it's probably unlikely that it still makes sense today. And it doesn't. It needs a major overhaul. There's so many challenges to this system that you know as well as I do, particularly as it relates to the administrative burden on chasing down payments, getting caught between counties that fight over the fiscal responsibility of survivors. It's not a survivor-centered system. We can't hold beds for individuals in shelter, for children who might have to leave for a court-ordered visitation with another parent, for a survivor who might have to go into the hospital. So very problematic. And we know that, as an infrastructure, the per diem reimbursement model really prioritizes shelter. When we're seeing more and more domestic violence survivors looking for non-residential services and support that they can obtain while staying elsewhere. And we also know New York State is the only state to bifurcate funding for residential and non-residential services. So right now, New York State, I think, has an awareness about the challenges of this system. OCFS, the Office for Children and Family Services, and OPDV, the Office for the Prevention of Domestic Violence, are together evaluating funding models in other states. And as I mentioned earlier, OCFS will be conducting a pilot project. They now have $15 million to conduct a pilot project to evaluate a specific alternative model for funding domestic violence survivors in the state. And that pilot project hasn't started yet. But all of which is to say, we still have this troubling system in place. New York State is evaluating other models, but we are really focused on change to make sure that we have an innovative, flexible, survivor-centered funding model in New York that works for domestic violence service providers. And the last thing I wanted to mention to you is bail and discovery. So you might have heard that there was a last minute proposal by the governor on bail reform and discovery in the last week of the budget negotiations. It sort of held up the final approval. And some aspects of her proposal did make it into the final budget. Now, we don't have to be experts on all of these changes that were made to the bail and discovery laws. But there's a couple of things I think it's important to note if the legislator asks for your opinion. And it's really more on the discovery side. So particularly in New York City, we were hearing several troubling accounts of domestic violence cases being dismissed really precipitously because of the prosecution's failure to comply with the new discovery laws that were put in place in 2019 and 2020. So those discovery laws require prosecutors to turn over all of the evidence on the case to the defense in a very short amount of time, like 35 days in several cases. Rather than trying to comply with that time frame, prosecutors were dismissing domestic violence and other cases. But the troubling aspect, not only because survivors don't get justice if a case is dismissed, but is that when a criminal domestic violence case is dismissed, it also dismisses the order of protection that a court might issue at the defendant's arraignment. So we were hearing cases where survivors didn't even realize they no longer had a valid order of protection against their abuser because the prosecution had dismissed the case. So that's extremely troubling. And in many of these instances, the substantial part of evidence, the substantial pieces of evidence had already been transferred to the defense. But there might have been one or maybe two pieces of evidence that were left behind, or that the prosecutor obtained or had difficulty obtaining. And that was mechanism enough, that was reason enough for the defense to motion to the court to dismiss the case. So what this new change, this 2022 change to the discovery law, ensures that no criminal cases, domestic violence or otherwise, will be dismissed because of minor technical violations in the discovery rules. And it's up to the court to review the information that was not provided and determine whether that justifies dismissal of the case or not. So we really think this is a very significant change that hopefully will modify how these cases are treated, particularly downstate. Now, with some of the bail changes, I don't really want to get into too much detail, but suffice it to say that they were really aimed at stopping the trafficking of illegal guns, stopping the cycle of repeat offenders, and investing in New York's mental health infrastructure, all of which we think are important. But it did move some crimes into the bail eligible category, and we do take issue with the whole approach of using bail as a means to keep defendants in jail pre-trial. We're not supportive of that approach. So we didn't actually take a position on these new changes to the bail side, but we did actively support the discovery law change. So just a couple of notes on that. And like I said, the bail reform and discovery laws are very complicated. It's not easy to talk about these in a high level way. The level at which legislators understand how these new laws impact domestic violence survivors is, could be limited. So we'll give you some information on this in the Q&A that we provide to you if it comes up. We just wanted to prepare you. And of course, in any case, if a legislator asks you a question or requests information that you don't feel comfortable providing or speaking to, just let us know, and NYSCADV is always happy to follow up. So Brittany, before I turn it over to you to complete the rest of the slides, do we have anything in the chat that I should be responding to?
I think we've answered all of the questions that came in.
Great. Well, I'm going to forward the slide, and Brittany, would you like to take it from here?
Sure can. Good afternoon, everyone. Thank you so much for being here. We're going to jump into some of the activities for the day. So we're going to start off our day of action with a morning session from 9 to 10:30 for all participants and stakeholders. We'll hear from Senate Majority Leader Andrea Stewart-Cousins, Senator Liz Krueger, Senator Cordell Clear, Assemblymember Linda Rosenthal, and Assemblymember Helene Weinstein. In addition, this year's morning session will include a brief panel discussion. The panel will feature 3 survivors who are working with the legislature on policy initiatives. We are really excited to be offering that this year. Again, we'll share around the link to register. Please note that registration is required to attend. You'll be receiving a personalized link into the morning session. Next slide. We're asking programs to schedule meetings with their legislators anytime from 10 a.m. to 5 p.m. It's up to you whether you want to meet in person or virtually. Just so folks know, the LOB is currently open, but visitors must enter through the concourse entrance. All of the exterior entrances are closed to the public currently. And if you do plan to do an in-person meeting, you must present either a COVID vaccination card or proof of a negative COVID test within the last 48 hours and an ID. So just so folks have that information, it's up to you how you would like to schedule these meetings, but that's what they're asking for if it's in person. There will be a resolution proclaiming April 26th as DV Prevention and Awareness Day in both chambers. Typically, these resolutions are at the beginning of session, but we won't know exactly when the resolution will be heard until that day. So that's all the information we have. But if folks are interested in hearing the resolution, it is going to be virtually available for folks to listen to. And the final thing for the day is we expect both chambers to pass DV-related legislation on that day. When that happens, we'll be sure to keep folks in the loop. Next slide. So if you're scheduling your meetings, we're asking you to do it soon. We are a couple weeks out from the day of. Each program is asked to schedule its own legislative meetings for the day. Please feel free to schedule as many as you have time for. Record your scheduled meetings here. This year is we have a tracker where we're going to ask folks to input any information you have about the meetings you are scheduling. It's a Google Doc, and we'll be sure to link that with materials that we sent out from today. If you are curious about who your legislators are, I will also provide these websites where you can go and find out who that is, or you can call the phone number as well to find out. If your legislator is unavailable, it's absolutely okay. Ask to meet with the chief of staff or legislative director. And if you have any issues scheduling these meetings, please feel free to reach out to me. I'm more than happy to help with scheduling or getting you in contact with the right person in that office. So what should you do before you meet? It's really important that you confirm when you're meeting and how you're meeting. Is it by telephone or Zoom or a different virtual platform, or is it in person? Who's arranging the conference call? And who's responsible for sending out the Zoom meeting invite? It's also really important to review the materials and identify your priorities. We had 6 priorities that Jen went over earlier. There is no way to get through all of that information in a 20 to 30 minute time frame. So don't feel like you have to do all of those. Pick 2 or 3 that you're really interested in and go with those. Know where your legislators stand on bills that you'll discuss. If you need help accessing that information, I'm more than happy to serve as a resource. And determine what you will ask each legislator to do. Next slide. So here are some tips for effective advocacy. It's really important that you strategize before your meeting. If it's virtual, I suggest meeting 10 minutes beforehand, just to figure out team roles. Who's going to be taking the lead, who's making the ask, who's sharing a story, and who's taking notes, just to make sure everyone is on the same page. It's really important to introduce everyone from your team. Stay focused. Stay focused on the action you want the elected official to make, and limit your conversation to the information most necessary. Avoid rabbit holes if possible. There are going to be difficult questions potentially, and it's okay, they happen. Don't be afraid to say that you're not sure what the answer is, and just politely avoid any confrontation. Legislators, we know, have strong opinions. Remember that we are trying to develop longstanding relationships with these legislatures. Even if they won't commit to your ask today, they may be helpful in the future. So it's really important not to burn any bridges or get emotional in these meetings, because there will be future follow-ups and relationships built there. Share stories. Personal narratives are more memorable than any statistics that we can provide. So if you have a story that really kind of hits home and resonates the need for any of these bills, share that story. Take notes. Make sure you're making a very clear ask and getting a commitment, even if that commitment is no. And then ensure that you are thanking everyone in the meeting. If they have interns there, everyone in that room, make sure to thank them, because we really do appreciate them taking the time to meet with us and chat about these issues. And then finally, follow-ups. Please complete and turn in post-meeting feedback forms after all of your meetings. These really help NYSCADV in reaching out and following up with any legislators that may be necessary. Make sure you're recording the names and titles of staff members that participated, and highlight any specific needs that came up. And also make sure NYSCADV is aware of any requests for information or unanswered questions. Although we offered information on 6 bills that are out right now, there are hundreds of other bills that impact domestic violence survivors that legislators may take the opportunity to ask you about. So just make sure you're noting those in the future as well. So let's talk about the toolkit for a minute. We're going to be providing a toolkit that will include hashtags, sample posts, template materials to provide to legislators, advocacy tips, and a social media campaign. So you do not have to worry about coming up with any of these on your own. These will all be on the website, which someone asked about earlier. Next slide. Okay. So here are some of the social media sample graphics. We know that social media is a great advocacy tool, both leading up to Day of Action and on the day of. Many legislators are particularly sensitive about what's being said to them or about them publicly and online. There's no harm in following or friending your legislators. As I said earlier, we're still working on this year's graphics and specific messaging, but these are a few of the graphics that we're working with currently. The one in the upper right-hand corner is actually information from the most recent DV census, and the other 2 are just graphics that can be shared with messaging. Next slide. We're going to be providing 2 virtual backgrounds that folks are welcome to utilize in your meetings. It looks really nice from an aesthetic standpoint when you're meeting with a legislator. If everyone has the same background, we know not everyone may be able to do this, but we are going to be offering 2 different options this year, and highly encourage that you utilize these well in those meetings. Next slide. So we wanted to include a few of our sample posts so folks can get an idea of where we're going with this year's social media toolkit. So this one, each will provide a Facebook or Instagram post and a Twitter post. Feel free to mix and match. Feel free, if there are things that don't feel like your page would say it, to change it up a little bit. But these are just some opportunities for ideas of what you can post to social media. So for example, New York State leads the country in demand for domestic violence services. Today, we join New York State Coalition Against Domestic Violence, along with advocates and survivors from across the state, to call on state lawmakers to ensure all DV survivors get the support they need. Utilizing the hashtag, they share safety for DV survivors. Just remember that any post that you put on Twitter has to be under 140 characters, so they'll be very, very short. Next slide. Here's another example. On just one day, DV advocates served over 6,600 victims of domestic violence, but due to lack of funding, 766 requests went unmet. Safety for DV survivors. New York's approach to funding services for DV survivors is outdated and leaves many victims behind. Survivors deserve access to residential and non-residential services equitably. The time for funding innovation is now. Earlier, someone asked in the chat about are we going to include materials around housing? So this is just a sample of how we're really kind of talking to legislators about really, making the funding available to be innovative for programs. Next slide. DV survivors' requests for services are complex, from legal assistance and childcare to financial assistance and advocacy. Yet New York's approach still prioritizes emergency shelter, overhaul the system now to better meet the needs of victims into the future. Okay, next slide. So finally, we've gone through some of our toolkit material, some of our messaging for the day. As we said earlier, this isn't finalized, but we really want to know, how can we best support you? Joan, has anything come up in the chat?
No, there was a question about Spanish Spanish translation or interpretation. So we're going to see if we can set that up for our morning program on Day of Action. My apologies for not making that available for this prep webinar, but we'll see if we can make that happen for the morning program. But nothing else in the chat just yet. So yeah, if anyone has recommendations on how we can better support you and your colleagues in your meetings with legislators, please, put something in the chat. If you have additional questions, we're going to stay here. I mean, this is the end of the webinar. Brittany and I will stay available for a couple of minutes to ensure that there's no last minute questions. You'll be getting a copy of these slides. And we also have our emails available to you, reach out if something does occur to you. We want you to be confident and secure in the information that you're going to be providing. So whatever assistance we can help you with, we're more than willing to make ourselves available to you. So thank you for being. Oh yeah, go ahead, Brittany.
I was just going to say, remember above all that now is the time to relay a really strong and unified message to our legislators, and y'all are the experts. So really kind of consider what you want your electeds to know.
I see a question about how to get access to the DV Directors listserv. That's through programs who have domestic violence as a primary purpose as their list of roles and responsibilities and the services that they provide. So if you have questions about whether your program would be eligible to participate, just send me an email and we can talk more about that offline. Well, thank you again. And like I said, we'll keep the lines open for another couple of minutes, but we will see you on the 26th, at least virtually.